Welcome, everyone. I'm Linda Caprera with the Maine State Chamber of Commerce, and I want to welcome you to our cannabis webinar. I just want to tell you up front, we are recording this live, so this will be recorded and available later. Just want to thank our sponsor, Freddie Flaherty, for this event. Today we'll be hearing from Dan Walker, Sarah Maupin, and Kristen Collins, part of the Freddie Flaherty Cannabis Practice Group that was founded and chaired by Dan Walker. The topics that we'll be discussing today are three topics. One is legislative and regulatory overview by Dan Walker. The second will be managing employee issues by Kristen Collins. And the third will be commercial and financial trends by Sarah Maupin. So I'm going to start with Dan Walker, and I'll introduce Dan. Dan serves as the chair of Freddie Flaherty's Government Affairs Group. He advocates for clients before the Maine legislature, the executive branch, and other state and federal government agencies. Dan has extensive knowledge of the citizen initiative process, having taken clients successfully through this process to business formation. Dan's focus is on regulatory issues, including election and campaign finance law, casinos and gaming, and the medical and adult use marijuana sector. So welcome, Dan. Take it away. And I just want to say before I say that, there will be a Q&A session for 5 minutes after each topic of discussion, and then there will also be a Q&A at the very end, and everybody will be muted. So again, Dan, take it away.
Thank you, Linda. Thank you, Chamber. Again, my name is Dan Walker. I am the chair of Freddie Flaherty's Cannabis Practice Group, which we started, we've been working on these for over a decade on these issues. I'm also the chair of our Government Affairs Group, and that's where my practice primarily lies. I'm going to share my screen here. Let me know if that's Linda, thumbs up.
Yep.
Okay. So that's me. So we're going to be talking for the next half an hour or so regarding what happened with the 130th Maine legislature, and then what's happened since then, since the Office of Cannabis Policy has gone into rulemaking over the summer and over the spring, and where we're at with new legislation and new rules. I wanted to bring, it wouldn't be a good discussion around this if we didn't talk a little bit about politics around what's going on. So just a very quick history lesson here in cannabis, very quick. In 1999, Maine was one of the first states to allow for medical marijuana. Fast forward about 10 years, there's a significant expansion of the medical marijuana program in 2009 at the ballot. I actually drafted that initiative, and that's how I got into this whole sector. That back in 2009, that expanded the program, expanded the list of debilitating conditions, created the whole concept of dispensaries, and that happened in 2009. 2016, adult use was passed at the ballot. All of these were roughly 60-40 votes, so all significant majorities. And then also significantly in 2018, Governor Mills was elected as governor. Soon thereafter, she created the Office of Marijuana Policy, now Office of Cannabis Policy, which really brought our cannabis program into modern times. The previous governor let this program languish. We only had a couple people working and overseeing the medical program. That administration would not even recognize what the voters had voted on at the ballot. So it took Governor Mills coming in and creating the Office of Cannabis Policy to really set our program forward in a real modern way. As you all know, we have a gubernatorial election coming up. And who knows what'll happen. We're about a 5 or 6 point difference right now. Governor Mills seems to be polling ahead, but if former Governor LePage were to be elected, we don't know if he would go backwards or he would maintain the modern Office of Marijuana Policy that we've got right now. Also, just very quickly, what are the differences between the two programs? The medical, we still have two programs, the medical program and the adult use program. Medical program still requires you to be certified by a doctor. Doesn't have to be a certain debilitating condition, but it does need to be a condition. Something that a doctor, physician's assistant, or a nurse practitioner would deem, that you would have therapeutic benefit. Adult use just requires you to be 21 and up. Also on the medical side, you can be below 21. The adult use side requires a very rigorous testing and tracking program. Ironically, the medical program does not require any of that. Municipalities are required to opt in to allow for the adult use program to work in municipalities. However, except for caregivers, really, municipalities do not need to opt in for basic caregiver operations, but everything else municipalities do need to, unless someone has been grandfathered in. So that's my very brief review of what are the programs. On their screen right now is the Committee of Jurisdiction. The Veterans and Legal Affairs Committee at the legislature now deals with all cannabis issues except for like tax issues, which would go to the tax committee, or energy issues, which would go to the energy committee, but everything really goes to the VLA committee. As you'll see on this, everything that's not highlighted are folks who are not coming back to the legislature next year. So the only ones coming back to the VLA committee will be Senator Hickman, who's the Senate chair, Senator Farron, who's the Republican lead, Representative Morgan Riley, and Representative Laura Sapika, who are both freshmen, will be second-year legislators if they are to be reelected. There was significant change that went on this session. Senator Hickman, Senator Lucchini was the former Senate chair. He resigned to take a position with the Biden administration, and Senator Hickman was appointed chair of that committee. So you have a lot of new members going forward. And so into this next session, there's going to be a whole new crop of legislators. But this group right here made significant reforms and made it, if you had to have a theme for what happened in the 131st legislature, it would be that it became more consumer friendly, more patient friendly on the medical side, and more licensee friendly on the adult use side. So the first bill that I want to talk about is a bill that it's entitled "An Act to Promote Equity and Increase Opportunities in the Cannabis Industry by Reducing Restrictions Related to Convictions for Drug Offenses and to Replace the term marijuana with the term cannabis in the Maine Revised Statutes." So this was sponsored by Representative Rachel Talbot Ross, who's a Democrat from Portland, who is very likely going to be the next speaker. This bill is, and the reason why, the word cannabis is a scientific term for cannabis. Marijuana is a vestige of the past. So right now, this bill changes all references to marijuana in state statute and state rule to cannabis. It also starts down the process. This is not expungement of past cannabis crimes. It starts down that road. So it makes it easier for someone to apply for a license who has had in the past would have been a disqualifying drug offense, but this would exclude cannabis related crimes that would have been authorized under the adult use program or the medical program. And it also reduces the period of time from 10 to 5 years after the completion of a disqualifying drug offense sentence that would disqualify someone from getting a license. So it's starting to really go in this movement towards social equity and reform. And going forward, we're going to see more of that as well. So the first number of slides I'm going to be talking about are around the adult use program. And then I will then talk about the medical program. The first issue that came up in the adult use program was that the Office of Cannabis Policy had put forward a number of rules the beginning of the winter, or the beginning of the year into the session. They were introduced into the legislature because they were major substantive rules, which require the legislature to approve of them. And so the legislature did approve of them. The VLA committee approved of them. The legislature as a whole approved of them. And I'll just go over very quickly what some of those highlights were. And these were approved during the legislative process and then went into effect on July 1st. These were the major substantive. So quickly, again, these are all making it more user-friendly. The Office of Cannabis Policy revised the video surveillance requirements to reduce the financial burden of these systems on the industry. The licensing application process was reconfigured to require detailed information at the active licensure phase rather than at the conditional licensure phase, allowing more people to get in, get the process going, and then start building your application, and then the actual details wouldn't be required till the very end. SOPs have been an issue all along. That technically it required folks to give their SOPs, give their trade secrets to the office, but they finally made that change so that you don't actually have to give your SOPs to the office, except for those related to the safe and proper operation of inherently hazardous substances, which is used in the extraction and manufacturing process. There was also regulations around licensing of brands and logos was clarified. Reusable packaging, which folks have always been asking for, was finally permitted going forward. It removes a number of references to law enforcement from the regs, and then it adopted new definitions that were already put in statute for marijuana trim, mother plant, immature marijuana plant, and seedling, and it made that consistent between the two programs. And then it had new provisions and clarifications related to the use of foyers in adult use stores to verify the age of prospective customers. The legislature had changed the law to actually allow people to enter into an adult use store to check ID before folks were not allowed even into the store before their IDs were checked, which is difficult in Maine in the winter. So this is a great clarification. So again, those were the rules that went into effect on July 1st, and they were approved in the last legislative session. So I'm going to talk about a number of bills right now, and then this summer, the Office of Cannabis Policy entered into routine technical rules to then implement a number of these new statutes that I'm talking about. And then once I talk about the statute, if necessary, I'll go in and talk about the rule which clarifies it afterwards. So the first bill was about improvements to Metric, which is the tracking system. I'm not going to go into any detail on this. If you want, there are a number of guidance documents on the Office of Cannabis Policy website. There's a whole host of information if you're ever looking for clarification on any of this on them, and you can also contact them, and there's classes that they provide on these as well. So it would, going forward in Metric, it will allow adult use cultivation facility licensees to track as one group cannabis plants that are at the same stage of growth and intended for harvest as a group. And then it allows tagging of that as a group going forward. So rather than tag everything individually, this is hopefully going to allow for some consistency. Unfortunately, no other state has really gone this direction, so Metric is trying to catch up with this. So I think ultimately it will be helpful, and I think they're working out the kinks of this right now. And this summer, the Office of Cannabis Policy did a series of tours around the state, looking for information around Metric, around this, trying to work on implementation of this. Next bill, an act to allow for a variance rate in the amount and potency of cannabinoids in adult use edible marijuana products or cannabis products. This is something that the industry had asked for. So when you're right now, when you're in the manufacturing process, when you're creating an edible product, there's a limit of 10 milligrams of THC that can be in one serving, and a limit of 100 milligrams that can be in a package. And if you even, when you're creating them, if you even go, a milligram, if that's something, over the 10 milligrams, then you'd have to throw out your product. So people have been asking in the industry for a variance rate. The legislature voted for it. They passed it this past session. So now there's a variance rate of up to 10% over the 10 milligrams. So, and then the allowable variance may not be less than 0.6 milligrams, okay, or greater than 5 milligrams. So you still want to get something that has, that approaches the amount of what you're looking for per edible serving. So you don't want to get too low. So you don't want to get 0.6 milligrams low or greater than 5 milligrams. And that's really also dealing with packaging. So the next bill is an act to improve testing requirements for adult use marijuana. This is really, when you hear people talk about final form testing, this is something, again, that the industry has been asking for a while. Folks have felt like, so the previously, well, let's get right into it. So this would move to final form testing. And I'll just get right into the rules. So the old rule here was that licensees were required to engage in mandatory testing whenever you transferred cannabis or cannabis products between licensees. And the mandatory testing was pretty rigorous. It was for filth and foreign materials, dangerous molds and mildews, harmful microbes, THC potency, homogeneity, cannabinoid profiles, water activity, other harmful chemicals, which are really heavy metals, residual solvents, and then starting in December of this year, they're adding pesticides. It's been easing the industry into this. And again, this is only on the adult use side. So all this testing, again, is only on the adult use side. And then so going forward, licensees are only going to be required to engage in mandatory testing of cannabis and cannabis products prior to transferring those items to an adult use cannabis store for sale to consumers. So it's just in that final point before going to the consumers, there's going to be a requirement that all this testing has been completed. And so it will exempt from testing any cannabis or cannabis products that have been previously subjected to mandatory testing that have. So if before this you have had a product that you're dealing, so say you have extracts in a manufacturing facility, and that has come forward, and that extract has been tested, and that has not undergone any further processing, manufacturing, or alteration that would result in an increase in the concentration of any contaminants or factors for which testing is mandatory. So if that has come to you and that is all tested, and you just simply put it into a product, that won't require further testing. So it's a little bit testing, I think some people probably on this understand that, other people that's got a little testing nerdiness, but it will save a lot of time and effort in testing on the adult use side. This next bill, an act to assist qualifying municipalities to defray the cost of opting in to permit adult use marijuana establishments. Municipalities have been asking for this for a while, and it was before, and there was a number of bills put into the legislature this past session around in what was called, revenue sharing. So those communities that had decided to allow for adult use cannabis facilities wanted a share of what was happening, of the costs of that. So they wanted a share of the sales tax coming back. That's not exactly what happened. What happened was that there's a fund which was in this part of this process. It was renamed the Adult Use Marijuana Public Health and Safety and Municipal Opt-in Fund. It was renamed that, and then because there was a lot of extra funding in that, municipalities, when you're opting in going forward into adult use, will be able to submit grant proposals to this to get up to $20,000 in reimbursed costs back. And there's a 3-year look back. So if you've opted in within 3 years, you'd be eligible. Folks who kind of came right out of the gates and opted in are not going to be eligible for this. and it's only going up through 2027. That's it. This first come, first serve basis. Okay, so this is interesting. I think a lot of folks will want to know the details around this. So this is an act to permit curbside pickup and limited delivery of adult use marijuana. Right now, or before this session, only delivery was allowed on the medical side. So a lot of folks just operated out of their houses, had grows going on in their house, and were allowed to be able to deliver to their patients on the medical side. Adult use was prohibited from the get-go to be able to deliver. This bill was put in to allow for delivery on the adult use side. And let's go into the details about that right now. So the rules that were passed that went into effect on September 1st, routine technical rules. This is one of the rules that was detailed in there. So before a retail store licensee may conduct sales by curbside pickup and/or delivery, they must submit approval. They must get approval from the Office of Cannabis Policy and submit an updated facility plan. So specifically for curbside, if you wanted to start doing curbside pickup, you have to prepare a facility diagram, locate a designated area for parking if pickup is outside of your licensed premises, updates to your security diagrams, and also cameras need to be installed to film the entirety of that transaction. For delivery updates, sales must be conducted from your retail store. There needs to be updates to the security plan, and also cameras need to be installed to film the entirety of the transaction. And just one thing that I didn't mention, the delivery allows for only delivery to residences. So not to motels, not to campgrounds, not to hotels, not to businesses, only to residences. But it also allows for delivery into non-opt-in municipalities. So you have municipalities that have been trying to stop, the sale in their towns. This is going to allow the delivery even into an opt-in town. But this is a quote. This last bullet here. You're a licensee, and the only folks this is an expansion of a retail adult use license for this delivery. So a retail adult licensee needs to ensure that the order is appropriately packaged and labeled and placed in exit packaging before the licensee or employees removes the order from the inside of the cannabis store and sends it out for delivery. I mean, folks can get creative if they want about how best to deliver out of your store to be able to provide extra products to people, but it all needs to be packaged, labeled, and sent before it's sent out to delivery. Your staff needs to be trained in ID recognition. You must still use metric and use sales delivery manifests. A big issue here is that the towns that you're delivering into, you need to understand where safe zones are in those communities that are receiving delivery. You cannot, one of the major issues here is you cannot deliver into safe zones. And those are, I think, technically like drug-free zones. So, around schools, a lot of public parks are those. So you need to understand where the safe zones are. And you cannot deliver, quote, tobacco products. And that's something I think is going to need to be hashed out a little bit, no pun intended, which would include electronic smoking devices, right? Vapes. So the definition of a tobacco product is any electronic smoking device and any component or accessory used in the consumption of a tobacco product, such as filters, rolling papers, pipes, and liquids used in electronic smoking devices, whether or not they contain nicotine. So it's something I think that will need to be clarified. This is moving on, another bill, an act to authorize certain off-premises sales of adult use marijuana. This will allow another license or an expansion of the retail sales license again, and it'll allow folks to be able to sell it at events, at a fair, at a community event. However, the event, it can only sell non-smokable cannabis products, so edibles. And the sale needs to be transacted in a tent or structure. So, and it can only allow in those 21 and over. OC, Office of Cannabis Policy, is still working on the rules on this one. So that was all about adult use. So what happened on in the medical program? One of the big issues in the medical program was that the Office of Cannabis Policy had been attempting to, for a while, pass new rules, updated rules. The rules have not been updated since the LePage administration. They're hopelessly out of date. They tried to update them. A lot of folks in the medical program thought that the program went too far, and the legislature then submitted legislation that required they were all major substantive rules anyway that needed to be approved by the legislature, but the legislature even required another step to require a full vote of the legislature before medical program rules could be implemented. As a result, the Office of Cannabis Policy pulled back and is continuing to have a series of stakeholder group meetings to talk further about what is appropriate for the medical industry. And so we should be seeing those hopefully this fall. Again, they'll basically, they haven't been updated for 5 years, and you can't even use the medical rules that are in print. You just need to use the statute. But the one bill that did pass was they put everything into this bill, 1928. I'll go through it fairly quickly. It updated the pediatric certification process to remove the requirement that a pediatric patient have one of several qualifying conditions to be certified by a provider without a second opinion. So it allows one provider to say that a underage person would get therapeutic benefit, and it doesn't. There were a lot of other hoops that they had to jump through, so it simplifies that process. It makes easier the telehealth process about getting certified to be able to use cannabis. It permits the acceptance of a digital image of a patient certification by registered caregivers and dispensaries to allow for transactions, so you can have it on your phone. It would allow, and I think this was just a something technical thing that needed to have been fixed, but it allowed registered caregivers, regardless of whether the caregiver operates a retail store, to accept remuneration for immature plants and seedlings. And this is a big one. It allowed employees of caregivers and dispensaries to obtain one single ID card within the system. When you're in the system in the medical program, you're required to get different ID cards. It was for everyone you worked for. Now you can have one, and then it can reference if you work at numerous operations. And then amended the definitions of cultivation and plant canopy for caregivers to allow them to maintain up to 2 separate cultivation areas. They still need to follow, the 30 plant or 500 square feet definitions, but it allowed for 2 separate areas. So that is what happened this past session. What's happened over the summer is that the Office of Cannabis Policy has really done a whole period of outreach, listening tours. Some of you may have gone to them. They've done a good job of trying to receive as much information as possible to see what changes are necessary, from both the medical program and the adult use program. And like I said, there was a specific one around the metric system, looking to make specific changes there. And I think that is it. So that was my presentation. And again, I represent our government affairs group. I do legislative regulatory work. Pretty Flaherty also has a strong municipal group that work, and all of these work within the cannabis field. Kristen, you'll be hearing from next, works within that group, although she'll be talking about employment issues. We also have strong commercial business and then litigation and employment. So anything you need, we operate within that world. So are there any questions before we switch back over to Kristen?
I think we have a question in the chat. Oh no, it's just Angie, sorry.
I think I missed that.
Okay, I guess there's no questions, so we'll move on to our next topic, which is managing employee issues. Kristen Collins is our speaker. She is a partner in Freddie Flaherty's Municipal Law and Finance Group, and she co-chairs the Municipal Broadband Group, practicing from the firm's Augusta office. She works with municipalities, landowners, developers, and citizens groups to find practical, efficient, and politically sensible approaches to issues touching on all areas of municipal law, including zoning, permitting, licensing, employment and labor, litigation, and finance, all of which are highly relevant to cannabis businesses. Welcome, Kristen.
Thank you. Everybody can see my screen, I hope. Yes?
Yes, looks good.
Thank you. Okay. So we are at a point now where, and I'll try to use cannabis to be with the times here, but we're at the point where cannabis use has become so ubiquitous and so normalized that any employer is really now faced with the situation where a good portion of its workforce is likely to be using marijuana, either cannabis, either recreationally or medically. And so this presentation is designed to just give you an overview of the things to think about when it comes to employees using marijuana in the workplace. So as you know, it is legal to grow, possess, and buy medical or adult use marijuana over age 21. We don't need to tell you, we have stores all over the place. You can walk right in and buy it without any sort of registration or prerequisite other than showing an ID. But marijuana use, of course, is still not legal under federal law, which creates its own, a host of issues that those of you who take federal grants or are subject to federal laws, such as commercial driver's license laws, there is still that overlay where we have to worry about compliance. The important thing on this slide to note is this fascinating statistic to me that 69% of 18 to 24-year-olds now say they prefer marijuana to alcohol. And so you have a large share of your junior workforce and what will soon be, the bulk of your workforce who's coming of age in a world where they are used to being able to legally use marijuana. They don't, have any sort of stigma attached to it. And they are using it just as perhaps your generation or my generation used alcohol, for fun on the weekends to relax at night. And so they will be coming into work in a situation where perhaps they're still intoxicated, or maybe they were the night before, and we have to deal with that. And an overlay that I'll give you just in general that I think is helpful is when it comes to marijuana, I suggest people think of adult use marijuana the same as alcohol. And so if you're left in a situation where, you are concerned about impairment, think about it as if you were thinking about alcohol, because it is just as legal and just as commonly used now as alcohol. And if you are dealing with medical use marijuana, think of it just as any other prescription drug. There's really not that much more to it. It just takes a little bit of a mindset shift. So just a little overview of medical use. It is not legal to use medical in any public place. And there's no exception for medical marijuana under federal law. So if you are one of those employers who is governed by a federal statute, then it does not matter whether the employee is using it medically for a disability. And it does not matter if it's adult use rec. Medical marijuana is available from dispensaries, caregiver stores, individual caregivers, and family members who are registered as caregivers. And it used to be for specific designated conditions under the statute. For the last couple of years now, it has been under the standard that the patient's medical diagnosis may be alleviated by therapeutic or palliative medical use of marijuana. So now it's a very low and very vague standard. Almost anyone with a pain condition, anxiety, anything like that, or frankly, whatever they tell the person who's giving them the certification is probably going to qualify for medical use. The certifying provider, and that could be a nurse practitioner or a doctor or a PA, must have taken 1 hour of instruction on medical marijuana within the last 2 years. And you'll find that medical or caregiver stores will often set up sort of clinics several days a week or 1 day a week where you can come in and get your card right on the spot, even though you don't have a doctor-patient relationship with that provider. So you can get your card. You don't have to get a card in order to use medical marijuana. It is available, as long as you have a doctor's note or from a nurse practitioner, et cetera. The reason you would get a card is to evidence that the marijuana that you possess is in fact for medical use, which gives you a certain degree of protection in some areas. So we'll talk about the ADA, which is one overlay of concern for discriminating against medical marijuana users. But there's also a state statute that's been in place for many years now, and that says that a employer may not refuse to employ a person solely because of that person's status as a medical marijuana user or as a caregiver, unless failing to do so would put the employer in violation of federal law or cause it to lose a federal contract. So for an employee who wants to have this bubble of protection around them, this is where they would need to have that card to evidence their status. Protection does not entitle the user to undertake any task under the influence of marijuana when it would constitute negligence or malpractice or violate any professional standards. So of course, you can use, but you can't let it impair your actual performance of tasks. You can't possess marijuana in school buses, on school grounds, or in a correctional facility. Can't use in any public transportation or any public place. And you can't operate a vehicle while under the influence of marijuana. And you can't necessarily use it while in the workplace. That said, an employer could accommodate that if it's reasonable under the circumstances. So as I just said, an employer may allow medical marijuana use, and that could be off premises or on premises in a way that it may cause them to actually be a little bit impaired during the workday. So, there's the, are you allowed to use it during work because that's what your provider is suggesting? Or are you allowed to use it, say, before work in a way that you may still be a little bit impaired? So obviously it's a sliding scale with a lot of factors to consider. You have to think about the employee's job performance. Is it actually impacting their ability to do their job? Does it put the employer at any risk of liability? So obviously you're going to think about a desk job a lot differently than you would think about someone who's operating machinery. And it, again, is a situation where an employee may come to you and say, look, I have this condition and I've been prescribed medical marijuana. I want you to know that I need to use it, and I'm looking for an accommodation. So again, very similar to a prescription drug, where someone may have been prescribed something that is likely to impair them to some small degree, and they come and ask for that accommodation or that consideration. So a disability under the ADA is a condition that substantially impacts one or more major life activities. And so if someone, for instance, is a cancer patient, or they're dealing with chronic debilitating pain, or even crippling anxiety or depression, and they have been prescribed medical marijuana, well, all of those conditions would qualify, I believe, as disabilities under the Americans with Disabilities Act. Now, there are some ones that are not so obvious. So what about someone who says they need to take it for stress, or they can't sleep sometimes, or they have occasional pain, and so they sort of treat as the issue comes? I would not consider those three conditions to be disabilities under the ADA. And why it matters is because, of course, if it's a disability, you're required to engage in this, disability accommodations discussion, and to try to figure out whether to allow them to use, whether inside or outside of the workplace, is an undue hardship or poses an undue risk to you, your business, as an employer. So if it is not a disability, the whatever condition that they are using for, then your analysis is going to really stop at that state statute we just discussed. And so the question then is, you are not required to allow someone to be impaired or to use in the workplace. And so it is really just a decision that is up to you as an employer, maybe as a matter of policy. But I would always suggest having a policy and following it so that you're not making arbitrary decisions. So to request an accommodation for marijuana use, you do not need a medical card, but you do need the medical opinion, just like any other accommodation that you might need. And so your expectation as an employer, if someone comes to you and says that they're using marijuana, or more often than not, it seems like it's reported by some other employee, or the employer comes into the knowledge. And at that point, you are free to talk to the employer about the fact that you're aware that they're using, and get the doctor's note. You then engage in a collaborative process with the employee, who is going to give you whatever the medical evidence is as to why they need it and how often they need to take it, and what the expected impairment might be. That's an important question. And then you need to think about, okay, if this is a serious medical condition and the person truly does need to use this as a medication, again, just like any other prescription, is there a dosing schedule that will keep them as not impaired as possible? Is there a modification to their job description that you need to make? And I know that sometimes, again, with medical marijuana, it seems a little strange to make accommodations for, but where prescribed, I think it's still very important to understand that you may have to take someone off of handling heavy machinery if you have the work for them that you can cobble together, for instance, as a desk job or a lower risk job, because it allows them to use that medicine that they need. But then, of course, undue hardship still comes into play. And so that's what comes in when someone is impaired in the workplace chronically. Their job is suffering, they are falling asleep on the job, that sort of thing. So you're required to tolerate medical use up to a point, and that point is when it poses an undue hardship on your business. And that very well may mean that for this job classification, for instance, you can't afford to take the person off of handling machinery, or they have to be in a safety sensitive role. So you can't allow the accommodation. But it may also be that over time, and you see the employee's performance slip to a point that it's unacceptable, that you can decide with the appropriate process around it that you can't allow that accommodation anymore because it's just causing too much impact. What I would suggest at that point is to send that person back to their doctor or their provider for an evaluation, because it very well may be a matter of dosing, timing, and what they're taking and when, and maybe that can be tweaked a little bit so that they can go back to being a high-performing employee. Testing, this has been a huge shift in the last several years. If you've got 70% of your young workforce saying that they prefer using marijuana to alcohol, well, that means that your testing results are going to trip for marijuana so much more. And I'm sure any of you out here who do drug testing are seeing that in real life. So when it comes to cannabis, drug testing is not the answer. That's my clear advice right now, unless you are dealing with Cdl employees or, you really need to find out whether people are violating federal contracts or grants. So your analysis, which is the standard way of doing drug tests, it detects cannabis metabolites in the bloodstream. Even after 1 week of using, about a quarter of the metabolites will still be in someone's body. They can trip a test, as you probably know, up to about a month after they've consumed. And so a positive result does not indicate impairment. Number one, that's the biggest concern. Number two, it doesn't even necessarily indicate someone who is a frequent user or someone who has used recently to the job application or to the test. So even when it comes to impairment testing, if you have an incident on the job and you send someone out for a test, it's not going to show whether whatever happened was in part or fully the result of them being impaired from cannabis. So this is a very tricky area when it comes to cannabis because it's still a regulated substance. You're still going to have workplace policies, and you're still going to have the risks of people causing harm because they're on cannabis. But to actually get to those people who are likely to cause you risk because they are using during work, that's the hard part. So the legislature has tried but failed to implement a THC standard for under the influence. So what I will say, and I'll come back to this again and again, is impairment is really the key. And impairment comes down to observable, quantifiable behaviors of the person. And the best thing that you can do is be trained in how to recognize that impairment. Whether it's the eyes, whether it's the speech pattern, or the physical movements, those are the things that are the biggest indicators of impairment. So many employers are removing pre-employment testing from their panels for all of these reasons. To even say in a job ad that someone is going to be subject to testing, including cannabis testing, is going to, or may at least, unnecessarily cut down on your applicant pool. And certainly if you're using it as a way to weed out people who have already, had their interviews and are marked as good applicants, it's going to weed out, pardon the pun, people who are qualified as well. And it may not be directly related to someone's ability to perform the job. So if you think about, someone working a desk job, if they're using somewhat responsibly, at least at home, and then come into work the next day, you're not going to see that person be highly impaired or probably affected in any discernible way. Versus, and it truly with an extreme level of alcohol impairment, people can come in the next day and still be quite impaired. So again, think of it as alcohol. The other reason that I don't think a lot of people think of why pre-employment testing may not be the greatest idea is there are so many medical marijuana users that if you test, and if the test trips for cannabis, guarantee you that employee is going to say, oh yes, I have to take that for whatever debilitating medical condition I have. And now that person in the employment, in the pre-employment process has tipped you off to the fact that they may have a disability. Now, what if you make the decision that you don't want to hire that person for any number of reasons? They are going to be able to say, well, this employer knew that I had a medical condition because I volunteered that to make the medical use okay. And I think that they made the hiring decision based on that. So, ADA violation or potentially just a violation of the state statute about discrimination. So our preference is, and our advice is always to focus on impairment testing post-hire and really, again, learn how to notice the signs of physical impairment. So pre-employment testing, though, is still and probably for, maybe a years to come, going to be required for CDL jobs. jobs where a firearm is carried, and any federally funded job. So what kind of tests could you look at if just recognizing physical impairment doesn't feel good enough to you? There are some app-based impairment tests that are on the market, and they're being refined and getting a little bit better. They test motor function, response time, and cognitive skills. But the problem with them is you can't just have it and expect to pull it out if you think someone is impaired. You have to create a baseline for that person. So immediately upon hire, you'd want to administer the test, find out what their baseline is, and probably continue to do that on, say, an annual basis, so that you have the baseline to which you can compare the potentially impaired test result. So also there are these things that are actually mobile brain scans that law enforcement are testing in some regions, and that actually are expected to get to the point where they could be consumer devices that employer could keep on hand. It actually shows, brain activity in certain areas that are indicative of impairment. So in terms of your policies, you should absolutely focus, you should have a policy, first of all, about drug and alcohol use in the workplace, and that should include cannabis. Focus on objective and provable violations. So for instance, no using on campus unless you've been granted an accommodation by the employer. No using during the workday, again, unless a doctor has certified the need and you've been granted an accommodation. No possession or use on campus. Watch out for cars. People tend to go out to their cars and use, so be specific about that one way or the other. No sale, transfer, or gift of marijuana on the premises. We're not going to be exchanging in deals while on the premises. And then to have some objective standard, perhaps, that says no using within X hours of operating machinery. So that's a little bit easier than if you get the employee who rats on another employee that says, I was at a party at their house at midnight and they were using, and now they're here at 6 a.m. and they're operating this machinery. Now you don't have to worry about the impairment per se, but if you can prove that they were using within 8 hours, for instance, then they violated your policy. Another thing would be, create that employee who does do the ratting out by requiring employees to report suspected use or impairment. So have people trained, have your foreman, for instance, if you're in a blue collar situation, trained to recognize impairment, and then have, any employee be required to tell management if they see someone using during the workday. Never forget in this day and age to think of home as a workplace. And so if you're defining use or possession in the workplace, think about what it means, for instance, to possess in the workplace, because of course, people have the right to have these things in their homes. But intoxication in the workplace should apply to people when they're at home. What about CBD and hemp? So these products really aren't regulated per se, but they are presumed not to cause impairment. The standard for CBD to be able to be sold as CBD is 0.3% or less THC. So, people are using CBD. You obviously can buy it all over the place at gas stations and whatever. And people who use that may have legitimate medical uses that would trigger an ADA claim, but because it's so easy to come by and you don't need a card or any note, they may not have doctor's certification that they're using for a medical purpose. And so if someone, says that they need to use CBD, it should be completely fine to you. If you're in one of these safety sensitive jobs, then what you want to focus on is having them prove to you that the CBD actually is under that 0.3% THC. Okay, so for Cdl drivers, simply put, no amount of cannabis in the system is okay. So whether it's medical, even if it's legally prescribed, it does not matter for the purpose of CDL. With CDL, traditional urinalysis and blood tests are still used. You still have to pass a pre-employment drug test, and you have to undergo testing in the event of a crash or where there's reasonable suspicion that you are under the influence. And you may also, depending on the policy, have to undergo random drug testing. Refusal to take a test is a failure. Failure requires a return to duty process, which does require going through a drug treatment program and not coming back to work until you've done so and test clean. CBD over that 0.3% THC, that's going to be an illegal drug under the CDL regulations, no matter what, because it does have more than that 0.3%. But it's also a problem if it trips the test. And so while it should not trip a test for people who use CBD even quite a lot, I have seen it happen, and it probably is happening because they are using CBD that's over the limit and using a lot of it. But who knows why it trips the test, but when it does, it can cause concerns. So for those of you who have CDL employees, it's important to sort of counsel them to be careful about the CBD they use. Try to buy it from a dispensary so they know it's been tested, and be extremely careful. So for federal contractors, there is the Drug-Free Workplace Act. That applies where you're performing work under a federal contract in the amount of over $100,000, or where it's funded by federal grant funds. And where that act applies to you as an employer, all the employees at your work site must be prohibited from engaging in the manufacture, distribution, dispensing, possession, or use of marijuana. So it's really about use in the workplace and not on personal time. So you don't have to be as harsh about a policy as you might have thought. And there's a misconception that if you're governed by the act, that you have to have a testing program, kind of like CDL. You don't in this case. But again, you do have to at least be able to have the ability to find out whether someone has used in the workplace, because that, of course, is a violation. Testing and compliance requirements, if you're a federal contractor, best place in the job ad so that you don't waste your time interviewing people who are not going to pass a drug test if you're going to administer one, or to people who are required to use during work time for a medical reason or otherwise. And that's all I've got. If there are any questions, I'm happy to take them.
Are there any questions that anyone has for Kristen? Okay, if not, we're going to move on to our third topic and final topic is commercial and financial trends. This will be Sarah Maupin. Sarah's a partner in Freddie Flaherty's real estate and finance and corporate and M&A practice groups. She advises clients in highly regulated industries such as healthcare, banking, and cannabis on business transactions, including entity formations, mergers and acquisitions, commercial finance, and general commercial law and contract issues. She provides across-the-board counseling for businesses from startup advice, capital raises, and debt financing to acquisition, growth, and the sale of the company. Welcome, Sarah.
Thanks, Linda.
Okay, Sarah, can you see the slides?
I can. So thanks very much. I'm having some technical difficulties today, so Angie's going to help me advance the slides. So let's talk first about cannabis. I want to talk today about the state of the industry. So as Linda indicated, I'm a transactional lawyer. I do business law, real estate, and commercial finance work primarily, some M&A work as well. So I'm going to be coming at this from that angle. And I want to talk about commercial contracts and some of the challenges we see in the cannabis industry around the federal illegality issue. So first, just a broad overview of the landscape. We know that most states currently have laws legalizing cannabis in some form. We also know it's still illegal under federal law. Under the CSA, cannabis is classified as a Schedule I drug, which means the federal government views it as highly addictive and having no medicinal value. What that means from a contracting perspective is there are challenges in the cannabis industry that you won't find in other industries. And that's what I really want to talk about today. So this is just another overview slide. There's this national shift in public opinion, and Kristen touched on this as well, and I do think it's really interesting. So in 1995, the year before California became the first state to legalize medical cannabis, only 25% of Americans polled favored nationwide legalization of cannabis. Fast forward to 2021, that same survey, 68% of Americans now favor legalization. So a strong majority here. So cannabis by the numbers. So I pulled all of this from the OCP December 2021 survey results. You can find those on the OCP website. I also found this to be really interesting because these are issues that I'm seeing a lot in my transactional practice. So 64% of cannabis is being obtained from regulated sources, which means 36% of it is still coming from the black market in the state of Maine. 54% of consumers who purchase from home-based caregivers do not have medical cards, that's a violation of state law. 33% of consumers who purchase from dispensaries or caregiver retail stores do not have medical cards, also a violation of state law. I also thought it was really interesting because we're seeing these price fluctuation issues. So for every $1 in demand for adult use cannabis in Maine, there's about $2 in supply right now. And we'll talk a little bit more about that later. So here are the adult use open data stats that you can find on the Office of Cannabis Policy website. Right now, as of August 31st of this year, there are 2,614 registered caregivers in the state of Maine. This is down from the all-time high of 3,257, which was in 2016. There are 28 active dispensary licenses right now and 14 that are pending approval. And then moving to adult use, 83 active cultivation licenses, 50 active manufacturing licenses, 105 adult use retail stores, and 3 adult use testing licensees. This is also from the Office of Cannabis Policy website. I don't know how up to date this is, and it's not particularly easy to read, but I think it gives you a helpful visual overview of how few municipalities have opted into adult use in the state of Maine. I mean, these blue dots show you where they're located, and they're primarily in southern and western Maine. Next slide. So what's happening now? As you know, from my perspective as a cannabis transactional lawyer, we're seeing a lot of product available in the market. I think we're all reading the articles and hearing from clients that prices are dropping. Everybody knows that energy prices are going up. And what I'm seeing a greater number of partnership disputes. So either caregivers at the holding company level or adult use who have multi-owner companies. We're seeing the relationships start to fray and unravel a bit. And what I'm finding is that it's more important than ever as a transactional lawyer to include really strong dispute resolution mechanisms in the operating agreements for our LLCs and the shareholder agreements for our corporations. I'm also seeing a fair number of partnership disputes and business breakups on the basis of theft. For example, where perhaps one partner runs the back office and is not on site on a daily basis. And these are typically medical businesses where there is no inventory or seed to sale tracking. And the other partner is the operational arm of the business. They're on site every day. And lo and behold, we find, the back office partner finds that the operational partner is stealing, or they are, they're not reporting all of the sales and they're pocketing the cash. It's very easy. So another important thing that we're working on right now is including forfeiture provisions in a lot of our LLC operating agreements and corporation shareholder agreements. And what these provisions do is if it can be proven that a business partner is stealing from his or her co-owners, it would cause that person to forfeit their ownership interests, usually for some nominal sum. In particular, it's often, the person's capital contribution. What did they contribute to the entity to start the business? And we have successfully helped several business partners at this point who were able to prove that their business partner was stealing, basically reclaim the business and take it from their thieving business partners. So those operating agreements, I think, we all know that OCP is requiring them now. And I think a lot of times business owners are so busy and so focused on the operational aspects of their business, they're giving these operating agreements, short shrift, and they are really important because when something goes wrong, they are the thing that saves you. So something to think about. We're also seeing quite an uptick in, could you go back? Yeah, thanks. We're also seeing quite an uptick in mergers and acquisitions and consolidations. Also, sadly, a real uptick in failed cannabis businesses. And I think, that will be the theme moving into the next 5 years or so. I think we're going to see more and more consolidation in the industry. And frankly, I think we're going to see a lot of people just drop out of the industry. They couldn't make it work. Next slide. So let's talk about Maine's residency debacle. This comes up for me quite a bit when I'm drafting operating agreements, shareholder agreements for cannabis entities. In August, I think we all know, Maine's medical program has a residency requirement that requires all owners of medical cannabis business to be Maine residents. In August, just a month ago, the First Circuit Court of Appeals struck down the Maine law that requires owners to be Maine residents. They found the residency requirement to be unconstitutional. And this was a First Circuit Court of Appeals case, so a lot of people were really watching it because it's the first federal appeals court to take this issue on. And I don't think it will be the last. And what they found was that the Dormant Commerce Clause, basically prohibits residency requirements. The panel relied on this Rohrabacher-Farr Amendment, which is a spending bill rider that forbids the Department of Justice from using federal funds to interfere in state legal cannabis markets. And they found that spending bill rider was evidence that Congress has acknowledged the existence of a market in medical cannabis, and therefore it's unconstitutional to discriminate against out-of-state investors. There is a Maine-based trade group of caregivers who has appealed the decision. So we're all just waiting at this point, and we'll see what happens. We know that there have been residency-based preferences in Detroit and Missouri that were similarly struck down on Dormant Commerce Clause grounds. And we also know that the Office of Cannabis Policy has already opened the adult use market to non-residents. Next slide. So some of what I'm seeing here, particularly around the residency issue and some of these other issues, is what I would call a real culture clash. You have sort of your industry pioneers who've been here from the beginning. Some of them, not all, have kind of a cowboy or can't we all just get along type personality. Varying levels of sophistication, varying levels of access to capital. But now we're also seeing this influx of the business community. A lot of out-of-state investors are now interested in the Maine market. They're typically sophisticated, but have little to no hands-on cannabis experience. They're really the money people. They are often frustrated by industry pioneers. And I see this disconnect quite a lot, where you have a business investor who goes into business with an operator and they just can't seem to get along. One advantage of the business community and the influx of investment is greater access to capital for the Maine operators. Next slide. So switching gears just a little bit, I want to talk about some important commercial contract provisions. This could come up in any number of contracts, distribution agreements, purchase and sale agreements, operating agreements for LLCs, shareholder agreements for corporations. There's this federal illegality problem. So we're seeing it, and one Superior Court judge in Maine has actually issued a decision on this as well. So we're seeing some federal judges and also some state judges refuse to enforce state law compliant cannabis contracts on the basis that cannabis is still illegal under federal law. That's really problematic. You spend a lot of time, energy, money negotiating, legally what everybody believes to be a legally binding contract with a counterparty. Your business is completely state law compliant. And then there's some contract dispute or a breach arises under the contract, and you go to court and try and enforce this contract against your business partner. And the federal judge says, oh, sorry, I can't help you. You're out of luck. Because cannabis is illegal under federal law, this technicality really, that is really alarming. So one thing we're trying to do, and, I don't know that this works 100%, but, a lot of us transactional cannabis lawyers are doing it in the hopes that it will help. We're adding arbitration clauses and mediation provisions to all of our commercial contracts. So a Maine court or a judge may be reluctant to enforce a contract between cannabis businesses that they consider illegal, but an arbitration provision would help temper this federal illegality defense. So if there was a dispute, you would take your dispute to arbitration instead of a federal or state court, and you would include a provision in your contract that says the parties may mutually agree upon, hopefully a cannabis-friendly arbitrator who's not gonna find this federal illegality problem. But you'd also include a provision that the parties agree not to raise any federal illegality defense. And that does seem to help. And we've seen it in other jurisdictions. Because once you have a binding arbitration decision, all you do is enter it with the court and it becomes binding. So that's one issue to be aware of. Next slide. So lease provisions, we see this a ton. Typically the cannabis operator is the tenant, but not always. We do some landlord leases, as well, but this particular slide is geared towards the tenant. So here are some important things to think about if you are a cannabis tenant and you're negotiating a lease. Municipal licensing in Maine can be really uncertain. The ordinances are often fuzzy and unclear. So we typically will always negotiate for a walk right, meaning you would be able to get out of the lease and just walk away and get a return of your security deposit if you're not successful in obtaining all of the necessary licenses and permits within, some period of time after signing the lease. And then fixtures and equipment, this comes up as well. I'm surprised how often I see this as silent in a lease agreement. So for example, the lights, the irrigation systems, the fans, the HVAC, often the tenant will pay for and install all of these things themselves, but you need to get some clarity in the actual lease on who will own those things at the end of the lease term. If you don't, you may find yourself in a situation where the landlord owns all of it. Live and work arrangements. I've seen a fair number of disputes around this. So for example, if you have a resident cultivator who's leasing a piece of property where they, live in the house and they, have a greenhouse out back, something like that, resident cultivators often become very comfortable and are reluctant to leave. And if I represent one, I typically try and negotiate for a purchase option at the end of the lease term, because this is not just their place of work. They've made this their home. Their family often lives there, their children. So that's something to really think about in a live-work arrangement. Find out if the landlord has third-party bank financing. They often do, and many banks have an outright prohibition on leasing to cannabis tenants in the mortgages that they record against the property. So you need to find out, and you need to get it in writing. You'd be surprised how often a landlord will lie to you and say, oh yeah, I checked with my lender, this is totally fine. And they have not checked with their lender. And I've seen a lender come after a landlord and tenant and try and boot a tenant on this basis after the landlord had lied to the tenant and told him that, you know, there was no problem with the lender and they had no concerns over a cannabis tenant. So I push my tenants to get something in writing from the actual lender that says the cannabis use is allowed, the tenancy. Beware of leases that include hidden profit shares. I see this all the time. I mean, landlords who are not in the industry, their perception, for better or worse, is that this is a cash cow and a gold rush. They will often include, these sort of profit share provisions in leases with cannabis tenants that they would not otherwise include in, a typical commercial lease. So you need to really read your lease and be aware of what it says. Be sure that the landlord is aware. This is another issue. It's a little different than the bank issue. I have seen tenants not tell the landlord what use, like they just don't tell the landlord at all that they intend for it to be a cannabis use. And, if you end up having a landlord who finds out later and the landlord is, morally, ethically, from a risk perspective, opposed to a cannabis tenant, it becomes a real quagmire, and it really sours, even if the landlord can't boot the tenant, it really sours a landlord-tenant relationship. So from my perspective, it's always best to be really upfront with your landlord as to, what's the exact use you plan to make of the property. And if you plan to expand your use, later, let's say you're only doing medical now and you plan to maybe co-locate adult use later on, write that into the lease, get the landlord's consent to it at the outset. Think about your business plan and what you need, 5 or 10 years into the future. Next slide. So don't forget about securities laws compliance. We see this all the time, kind of these do-it-yourself cannabis business owners who take on investors. We all know there's a high monetary barrier to entry into certain types of cannabis uses. So many cannabis companies will take on and raise money through outside investors, but taking investment money without giving voting rights to the investors, what we call, in securities law world, passive investments. It's considered a security under federal law, which means you have to follow federal and state securities laws, and you typically have to make exemption filings with state and federal regulators. And it absolutely requires the involvement of an experienced securities lawyer. This is not something you can do yourself. It's one of the very few things that I would say in the legal world that you cannot and should not do yourself. The risk for taking, if you take on a securities, and if you take on an investor and you fail to comply with securities laws, the risk is if the relationship sours with the investor down the road, the investor can void the investment and demand all of their money back. Next slide. This is a fun one, I think. We're seeing more and more of this. Don't poach the IP of an established brand. So we're increasingly seeing well-known, I'm using the example of candy companies because I just think it's so interesting. They're asserting IP rights against cannabis companies that are selling either look-alike edibles or products that use a play on a very well-known and famous brand name. One example is last year, the maker of Skittles sued this California edibles company called Skittles branded cannabis, edibles for trademark infringement. The case is still pending, and I suspect the cannabis company is definitely going to lose. Efficiency Maine Trust. So this is not brand new, but it's new within the last few years. For a long time, the Efficiency Maine Trust would not make its programs available to cannabis businesses. They were worried, Efficiency Maine Trust takes a security interest in collateral a lot of times under these grant programs and their loan programs. And they were worried about the collateral risk of having a security interest in, federally illegal products. In late 2020, they had a change of heart. Their board voted to allow cannabis businesses to use their program. If you're not familiar with Efficiency Maine Trust, it's a ratepayer funded agency that oversees state programs designed to reduce costs associated with energy efficiency upgrades. So this can be a great opportunity to provide or obtain energy efficiency grant dollars, loans, and other financial incentives for LED lighting, advanced HVAC systems, standalone dehumidifiers, and all kinds of other energy efficiency upgrades. In 2021, the Efficiency Maine Trust's annual report notes that it saw considerable interest and program participation from cannabis cultivation facilities. So we know that some cannabis companies are taking advantage of these programs. Cannabis and bankruptcy. And I think this will become more of an issue as we see more and more consolidation in the industry. If the prices continue to drop, we'll see more companies struggle, and we'll potentially see more companies fizzle out. They won't be able to make a go of it. For other industries, bankruptcy can be a really effective tool for a struggling business to obtain some breathing room from creditors, restructure their debts, and escape certain litigation and collection efforts. But historically, cannabis businesses have not been able to use bankruptcy courts at all. The bankruptcy relief is unavailable to businesses whose activities are illegal under federal law. And there's been quite a push in recent years to try and get, sort of the American Bankruptcy Association and the trustees groups to sort of change their stance on that. And they really haven't. They're holding strong on this for now. So some other options, if your business is struggling and you need some relief from your creditors, state law receivership may be an option in Maine. It's quite expensive, but it is very effective. Some other options would be out-of-court workouts with your individual creditors. So basically just going to them and negotiating an out-of-court deal. An assignment for the benefit of creditors where you're just assigning assets. And then potentially if you have secured creditors, like an Article 9 foreclosure, where the creditor comes, takes their stuff and sells it at an auction. So finally, cannabis banking. Why do cannabis businesses have so much trouble accessing banking services and payment systems? I feel like this has been talked about a lot recently, and I think those of you in the industry are well aware of the issues and the heartburn over this. But there's no safe harbor from federal prosecution concerning cannabis enforcement under the CSA, which means, as a matter of policy and practice, prosecutors and regulators could go after these banks at any time because they are, aiding and abetting federally illegal activity. That hasn't happened. The prosecutors and regulators have really focused their attention on the prosecutorial priorities outlined in the Cole memo, despite the Sessions memo, which I'm not going to get into those details, but the policy and practice of no or limited federal enforcement could change at any time. And I think, that makes, financial institutions, banks, credit unions, that makes their boards nervous. And although it hasn't happened, it could happen. The other thing is that financial institutions are responsible to regulators who are independent from the Department of Justice and the executive branch. So even if you're not seeing federal prosecutions, the bank regulators or the credit union regulators could come down on these banks, if they feel like they're not compliant. And we've seen quite a bit of that with Seaport in the last year. I think many of you are well aware of all of the new requirements that Seaport is cramming down, and some of the other federal credit unions as well. And that came directly from the National Credit Union Administration. So Seaport is not unilaterally trying to cram these things down. Their federal regulator is mandating it, or they're threatening to close their program. Unfortunately, banking certainty doesn't seem like it will come until a federal fix is adopted. And even with a federal fix, the compliance burden, I think, will largely be the same or even more highly regulated. We're seeing that in, the Safe Banking Act. If that were to pass, it requires a whole new set of federal regulations. So even when the banks are open, I think, unfortunately, the cannabis industry is going to be subject to a lot of scrutiny by their banks, and they're going to continue to have all of these compliance requirements for their banks, and perhaps even more than we're seeing right now. Next slide. That's it. If there are any questions, I'd be happy to answer them.
Are there any questions on any of the presentations at this point? We're going to have an open Q&A session. So if anybody has any questions at all, whether it be for Sarah, Dan, or Kristen, please ask them. Okay, I guess there are none. That's okay. Well, again, I'd like to thank our three presenters today, Dan Walker, Sarah Maupin, and Kristen Collins, who are part of the Pretty Flaherty Cannabis Practice Group. I want to thank all of you for participating in this cannabis webinar, and I'd like to thank Pretty Flaherty, our primary sponsor for this. All presentations will be on the Chamber's website, so you can access them, and please feel free to call any of the attorneys that you heard from today, for any additional comments or anything. So with that, I'd like to thank all of you for participating, and again, be on the lookout for any of the Chamber's webinars in the future. We have a number of them coming up, so thank you all, and talk to you soon. Thank all of you.